Section 303, Statement in lieu of prospectus. 1. A public company shall, within 28 days after incorporation, or after its conversion from a private company in accordance with Section 302, deliver to the registrar for registration a statement in lieu of prospectus, signed by every person who is named in the statement as a director or a proposed director of the company or by the agent of that person authorized in writing, in the form and containing the particulars set out in Part 1 of the 9th schedule and, in the cases mentioned in Part 2 of that schedule, accompanied by the financial statements and reports specified in the schedule. 2. A copy of the statement in lieu of prospectus shall be delivered to the Commission. 3. A statement in lieu of prospectus delivered under subsection 1 shall, where the persons making the report specified in Part 2 of the 9th schedule have made any adjustments as are mentioned in Paragraph 27 of that schedule, have endorsed on the statement or attached to the statement a written statement signed by those persons setting out the adjustments and giving the reason for the adjustments. 4. Where a company contravenes subsection 1 or 3, the company and an officer of the company who is in default is liable to pay to the registrar an administrative penalty of 500 penalty units. 5. Where a statement in lieu of prospectus delivered to the registrar under subsection 1 includes an untrue statement or omits truthfully to state any of the particulars required to be stated by virtue of the 9th schedule, then a person, which expression for the purposes of this subsection does not include the company itself, who authorized the delivery of the statement in lieu of prospectus for registration, commits an offense and is liable on summary conviction to a fine of not less than 250 penalty units and not more than 500 penalty units, or to a term of imprisonment of not less than 1 year and not more than 2 years, or to both the fine and the imprisonment, unless that person proves that the untrue or omitted statement was immaterial, or that that person had reasonable grounds to believe and did, up to the time of delivery for registration of the statement in lieu of prospectus, believe that the untrue statement was true. B. An allotee who acquired shares or debentures in the company in reliance on the statement in lieu of prospectus, and who was misled by the untrue statement or omission, is entitled to rescind the allotment of those shares or debentures and to recover from a person guilty of an offense under paragraph A, whether convicted or not, compensation for a loss which the allotee has suffered by reason of that reliance. Or C. A person who acquires shares or debentures in the company from an allotee in reliance on the statement in lieu of prospectus, and who was misled by the untrue statement or omission, is entitled to recover from a person guilty of an offense under paragraph A, whether convicted or not, compensation for a loss which that person has suffered by reason of that reliance. Section 304, Prospectus on invitations to the public to acquire or dispose of securities. 1. Despite Section 294, an invitation to the public to acquire or dispose of any shares or debentures of a public company may be made if a. Within 6 months before the making of the invitation there has been delivered to the Commission for examination and approval by the Commission in accordance with Section 308, a prospectus relating to the shares or debentures complying in all respects with relevant provisions of Sections 305 to 307, and that prospectus has been registered with the registrar. B. Except as provided in subsection 2 of this section, a person to whom the invitation is made is supplied with a true copy of the prospectus at the time when the invitation is first made to that person. And C. A copy of the prospectus states on its face that it has been approved by the Commission and the date of the approval indicated. 2. Electronic media with the prior consent in writing of the Commission or a newspaper may publish an advertisement or otherwise a summary of the contents of a prospectus, duly approved in accordance with Section 308, so long as the summary A. does not contain a form of application for any shares or debentures which has not been approved by the Commission, or, in respect of shares or debentures dealt in or to be dealt in on an approved stock exchange by that stock exchange. And B. States with reasonable prominence where copies of the full prospectus may be obtained and the fact that it has been approved and the date of approval. Section 305, General and Restricted Invitations to the Public. 1. Except as provided in Section 306, where the invitation invites the public to acquire shares or debentures of a public company, the prospectus referred to in Section 304 shall state the matter specified in Part 1 of the 10th schedule and set out the report specified in Part 2 of that schedule. 2. Subsection 1 shall not apply to a. An invitation by a company in respect of shares or debentures of that company or any of the associated companies made solely to the existing shareholders or debenture holders of that company, or b. An invitation by a company in respect of shares or debentures of that company which are in all respects uniform with shares or debentures of that company previously issued and for the time being dealt in on an approved stock exchange. 3. A prospectus relating to an invitation to the public to acquire or dispose of shares or debentures of a public company, which is an invitation not falling within subsection 1, because it does not invite the public to acquire shares or debentures, or because it is excluded from the ambit of that subsection by virtue of subsection 2, need not state the matters or set out the report specified in the 10th schedule. 4. The prospectus referred to in subsection 3 shall not contain an untrue statement and, if the shares or debentures to which the prospectus relate are dealt in on a stock exchange, whether in the Republic or elsewhere, or if an application has been, or is being made to a stock exchange for permission to deal in those shares or debentures, the prospectus shall a. State that the shares or debentures are dealt in on that stock exchange or that application has been or is to be made for permission to deal in those shares or debentures on that stock exchange. b. State whether or not that stock exchange is an approved stock exchange within the meaning of this Act, and c. Contain the particulars and information required by that stock exchange, and in any other case shall state that the shares or debentures are not dealt in on a stock exchange. 5. An invitation falling within a. Subsection 1 is in this Act described as a general invitation, and b. Subsection 3 is in this Act described as a restricted invitation. Section 306, Certificates of Exemption. 1. Where it is proposed to make a general invitation to the public to acquire shares or debentures of a public company, the Commission may, on the request of the applicant, grant exemption in respect of compliance with any of the requirements of the 10th schedule, having regard to the proposals as stated in the request as to the size and other circumstances of the invitation. Compliance with the requirements of the 10th schedule would be burdensome. 2. A certificate of exemption specified in this section shall state that having regard to the proposals as stated in the request as to the size and other circumstances of the invitation, compliance with the requirements of the 10th schedule would be unduly burdensome. 3. Where a certificate of exemption is granted and the proposals are adhered to, a prospectus containing the particulars and information required by the Commission if duly published in the manner required by the Commission, shall be deemed to be a prospectus complying with the 10th schedule. Section 307, Consent of Expert. 1. Where a prospectus relating to an invitation to the public in respect of shares or debentures of a public company, whether a general invitation or a restricted invitation, includes a statement purporting to be made by an expert, the prospectus shall not be delivered for approval unless a. The expert has given a written consent, and has not, before delivery of the prospectus for examination and approval in accordance with Section 308, withdrawn the consent to the publication of the prospectus with the inclusion of the statement in the form and context in which it is included. And b. A statement that the expert has given and not withdrawn the consent appears in the prospectus. 2. Where, after delivery of the prospectus to the Commission for examination and approval, the expert withdraws the consent, the person who delivered the prospectus for approval shall immediately notify the Commission. 3. In this section the expression expert includes lawyer, engineer, valuer, accountant, assayer and any other person whose profession or calling gives authority to a statement by that person. Section 308, Registration of Prospectus. 1. A prospectus delivered to the Commission pursuant to Section 304 shall be delivered in triplicate. 2. Where a general invitation is being made by or on behalf of a company in respect of the shares or debentures of the company, one copy of the prospectus delivered to the Commission shall be signed by every person who is named in the invitation as a director or proposed director of the company or by the agent of that person authorized in writing, as well as being signed, in the manner referred to in subsections 3 and 4, by or on behalf of any other person also making the invitation. 3. In every case, one copy of the prospectus so delivered shall be signed by the person making the invitation or by the agent of that person authorized in writing. 4. Where the person making the invitation is a firm or body corporate, it is sufficient if the prospectus is signed by or on behalf of the firm or body corporate by not less than half the partners or by not less than 2 directors of the body corporate, and any of those partners or directors may sign by the agent of that partner or director authorized in writing. 5. One copy of the prospectus so delivered shall have endorsed on it or attached to it, a consent of an expert required by Section 307, and b. in the case of a prospectus relating to a general invitation, a certified copy or translation of each of the documents required to be available for inspection in accordance with paragraph 45 of the 10th schedule, or, where a certificate of exemption has been granted pursuant to Section 306 required to be available for inspection under the regulations of the approved stock exchange, but if a copy or translation of the document has already been delivered by the company to the registrar for registration, the registrar may dispense with the need to endorse or attach a further copy of the document, where in the opinion of the registrar, the copy originally delivered is readily identifiable and accessible. 6. Where the prospectus relates to shares or debentures dealt in on an approved stock exchange or states that application has been or will be made to an approved stock exchange for permission to deal in the shares or debentures to which the prospectus relates, there shall be delivered to the Commission with the prospectus a certificate by or on behalf of that approved stock exchange that a. The prospectus has been scrutinized by the stock exchange, and b. Its requirements relating to the contents of the document have been satisfied, and the registrar shall register the prospectus within 48 hours of the approval by the Commission of the prospectus. 7. In a case which does not fall within subsection 5 or 6, the registrar may, for the purposes of reaching an opinion on whether a prospectus a. does not comply with this act, b. contains an untrue statement, c. omits to state a material fact, d. is otherwise incomplete or misleading, refer the prospectus to the Commission for the opinion of the Commission, and the Commission shall give its opinion within 21 days after the reference, in relation to the prospectus. 8. A copy of a prospectus which has been delivered for registration in accordance with this section shall state at its head the following: a copy of this prospectus has been delivered to the Securities and Exchange Commission in accordance with subsection 8 of Section 308 of the Companies Act, 2019, Act 992. For the financial soundness of the company or the value of the securities on offer, investors are advised to consult a dealer, investment advisor, or any other professional for the appropriate advice. 9. For the purposes of this Act, and until the contrary is shown, the first publication of the prospectus is the date of registration. Section 309, Waiting Period. 1. For the purposes of this Act, waiting period means a period of 21 days after the first publication of a registered prospectus, or a longer period that is stated in the prospectus as the period before the expiration of which applications, offers or acceptances in response to the prospectus will not be accepted or treated as binding. 2. For the purposes of subsection 1. Where the shares or debentures to which the invitation relates are dealt in on a stock exchange, or where the prospectus states that application has been or will be made for permission to deal in the shares or debentures on a stock exchange. And b. To comply with the requirements of that stock exchange, it is necessary to advertise the prospectus in one or more daily newspapers of national circulation. Then, unless the prospectus is advertised, there has not been a publication of the prospectus. 3. A binding contract or legally enforceable obligation shall not be entered into in response to an invitation to the public in respect of the shares or debentures of a public company until after the expiration of the offer period, and an application, offer, or acceptance by a person in response to the invitation is revocable by that person at any time before the expiration of the offer period. 4. Subsection 3 does not invalidate a genuine underwriting agreement in respect of those shares or debentures. Section 310. Withdrawal of applications after the offer period. Where a general invitation is made to the public in respect of the shares or debentures of a public company, an application for the shares or debentures is not revocable during a period of 7 days immediately after the expiration of the offer period unless, before the expiration of the period of 7 days, a person responsible for the prospectus has, in accordance with Section 313, given public notice having the effect under that section of excluding or limiting the responsibility of the person giving it. Section 311, Invitations in respect of securities to be dealt in on a stock exchange. 1. Where a prospectus, issued in connection with a general or restricted invitation to the public to acquire shares or debentures in a public company states that application has been or will be made for permission for the shares or debentures to be dealt in on a stock exchange. An agreement to acquire those shares or debentures made in pursuance of that prospectus shall become void if the application is refused by that stock exchange or if permission to deal in the shares or debentures is not granted within 28 days after the expiration of the offer period. 2. Where an agreement becomes void in accordance with subsection 1, the person or persons making the invitation shall forthwith repay and restore without interest the money and other property received from a person in response to the invitation. 3. Where the money or other property is not repaid or restored in accordance with subsection 2, within 8 days after it becomes repayable or returnable, the person or persons making the invitation and, in the case of a body corporate, the directors of that body corporate is or are jointly and severally liable to repay that money or restore that property with interest at the yearly interest rate of a 91-day government treasury bill on the amount or value from the expiration of the 8th day. 4. A director is not liable under subsection 3 if the director proves that the default in the repayment of the money was not due to the misconduct or negligence of the director. 5. So long as the person making the invitation may become liable to repay the money in accordance with subsection 2, the monies received in response to the invitation shall be kept in a separate bank account and shall be held on trust to give effect to this section, and where there is a default in complying with this subsection, the persons making the invitation and, in the case of a body corporate, every officer of the body corporate who is in default is liable to pay to the registrar an administrative penalty of 750 penalty units. Section 312, Minimum Subscription. 1. Where a public company makes a general invitation to the public to subscribe for any of the shares or debentures of the company, the amount of money payable on application for the shares or debentures shall not be less than 20% of the subscription price. 2. Unless, within 28 days of the expiration of the offer period, the amount stated in the prospectus as the minimum amount of money which, in the opinion of the directors, must be raised in order to provide for the matter specified in subparagraph B of paragraph 22 of the 10th schedule, in this section called the minimum subscription, has been subscribed and the amount payable on application for the minimum subscription has been paid to and received by the company, an agreement to subscribe for those shares or debentures shall become void at the expiration of the 28 days. 3. Where an agreement becomes void in accordance with subsection 2, the company shall repay without interest the monies received from any persons in response to the invitation. 4. If the money is not repaid in accordance with subsection 3, within 8 days after it becomes repayable, the directors of the company are jointly and severally liable to repay that money with interest at the yearly interest rate of a 91-day government treasury bill on the amount or value from the expiration of the 8th day. 5. A director is not liable under subsection 4, if the director proves that the default in the repayment of the money was not due to the misconduct or negligence of the director. 6. So long as the company may become liable to repay the money in accordance with subsection 3, the monies received in response to the invitation shall be kept in a separate bank account and shall be held on trust to give effect to this section, and where there is a default in complying with this subsection, the company and every officer of the company who is in default is liable to pay to the registrar an administrative penalty of 750 penalty units. Section 313, Civil remedy for misstatements or omissions in a prospectus. 1. where a prospectus published in connection with a general or restricted invitation to the public in respect of shares or debentures of a public company contains an untrue statement or omits to state any of the particulars or to set out any of the reports which, under this Act, it is required to state or set out, subject to this section, a person specified in subsection 2 is liable to pay compensation to the persons who acquire or dispose of the shares or debentures on the fate of the prospectors for the loss they may have sustained by reason of the untrue statement or omission. 2. Subject to this section, the following persons are liable to pay compensation in accordance with subsection 1. A person making the invitation to which the prospectus relates. B. A person who was a director of a body corporate making the invitation at the time when the prospectus was published. C. Where the invitation was made by the company to whose shares or debentures the invitation relates. 1. A person who has personally authorized to be named and is named in the prospectus as a director or as having agreed to become a director, immediately or after an interval of time, or 2. A promoter of the company who was a party to the preparation of the prospectus. And D. A person who, pursuant to Section 307 has consented to the publication of the prospectus containing a statement by that person as an expert. 3. A person is not liable under subsections 1 and 2 if that person proves a. That as regards an untrue statement, not purporting to be made on the authority of an expert, other than that person, or of a public official document or statement, that person had reasonable grounds to believe and did believe up to the time of the publication of the prospectus or, where a waiting period applies, up to the expiration of the waiting period, that the statement was true. B. That as regards an omission, that person was not cognizant of the omission up to the time of the publication of the prospectus or, where a waiting period is applicable, up to the expiration of the waiting period. C. That as regards an untrue statement purporting to be a statement by an expert, other than that person, or contained in what purports to be a copy of or extract from a report or valuation of an expert, it fairly represented the statement, or was a correct and fair copy of or extract from the report or valuation, and that that person had reasonable grounds to believe and did believe up to the time of the publication of the prospectus that the person making the statement was competent to make it and had given the consent required by Section 307 and had not withdrawn that consent before the date of registration of the prospectus. D. That as regards an untrue statement purporting to be a statement made by an official person or contained in what purports to be a copy of or extract from a public official document, it was a correct and fair representation of the statement or copy of or extract from the document. E. That after the publication of the prospectus but before the expiration of a waiting period that person, on becoming aware of an untrue statement in the prospectus or omission from the prospectus withdrew the consent given to the prospectus and gave reasonable public notice of the withdrawal and of the reason for the withdrawal, or F. That the prospectus was published without the knowledge of, and that, on becoming aware of the publication, that person forthwith gave reasonable public notice that it was published without the knowledge of that person. 4. A person specified in subparagraph I of paragraph C of subsection 2 is not liable under subsections 1 and 2 if that person proves that having consented to be named as a director or as having agreed to become a director the consent was withdrawn before the registration of the prospectus and that it was published without the authority or consent of that person. 5. A person specified in paragraph D of subsection 2 is not liable under subsections 1 and 2 of this section. A. If the untrue statement or omission was not made by that person. B. If that person proves 1. That as regards an untrue statement made by that person was competent to make the statement and had reasonable grounds to believe and did believe, up to the date of publication of the prospectus or, where a waiting period applies, up to the expiration of the waiting period, that the statement was true. 2. That having given the consent under Section 307 that person withdrew the consent in writing before delivery of the prospectus for registration. 4. A person specified in subparagraph I of paragraph C of subsection 2 is not liable under subsections 1 and 2 if that person proves that having consented to be named as a director or as having agreed to become a director, the consent was withdrawn before the registration of the prospectus and that it was published without the authority or consent of that person. 5. A person specified in paragraph D of subsection 2 is not liable under subsections 1 and 2 of this section. A. If the untrue statement or omission was not made by that person. B. If that person proves 1. That as regards an untrue statement made by that person was competent to make the statement and had reasonable grounds to believe and did believe, up to the date of publication of the prospectus, or, where a waiting period applies, up to the expiration of the waiting period, that the statement was true. 2. That having given the consent under Section 307 that person withdrew the consent in writing before delivery of the prospectus for registration. 3. That, after delivery of the prospectus for registration but before publication of the prospectus, or, where a waiting period applies, before the expiration of the waiting period, that person, on becoming aware of the untrue statement or omission, withdrew the consent in writing and gave reasonable public notice of the withdrawal, and of the reason for the withdrawal. 6. Where a person is named in a prospectus as a director of a company or as having agreed to become a director of a company, and that person has not consented to become a director or has withdrawn that consent before the publication of the prospectus and has not authorized or consented to the publication. Or B. The consent of a person is required under Section 307 to the publication of the prospectus and that person has not given that consent or has withdrawn the consent before the public cartoon of the prospectus, a person making the invitation to which the prospectus relates and a person who was a director of a body corporate making the invitation at the time when the prospectus was published, except a person without whose knowledge or consent the prospectus was published, is liable to indemnify the person referred to in paragraph A or B of this subsection against the damages, costs and expenses to which that person may be made liable by reason of the name having been inserted in the prospectus or of the inclusion in the prospectus of a statement purporting to be made by that person as an expert, or in contesting legal proceedings brought against that person in respect of the prospectus. Section 314. Rescission for misstatements in a prospectus. 1. Where a person acquires shares or debentures of a public company from that company or disposes of shares or debentures of a public company to that company as a result of an untrue statement of a material fact made, whether innocently or fraudulently, in a prospectus published in connection with an invitation to the public made by or on behalf of that company, that person is, subject to subsection 2, entitled to rescind the acquisition or disposition of the shares or debentures. 2. A person is not entitled to rescission unless that person claims to rescind with reasonable promptitude after discovering that the untrue statement was made and, in any case, before the commencement of the winding up of the company. Section 315. Voting rights of shares offered to the public. 1. An invitation shall not be made to the public to acquire shares in a public company unless the voting rights attached to the shares of the company are stated as required by sections 52 and 53. 2. Where a person makes an invitation to the public in breach of subsection 1, that person is liable to pay to the registrar an administrative penalty of 1,000 penalty units, and if the invitation is made by or on behalf of the company, and each officer of the company who is in default, is liable to a like penalty. Section 316. Public invitations to deposit money with public companies. 1. Despite Section 294, an invitation to the public to deposit money with a public company may be made if a. The public company is licensed, under the Banks and Specialized Deposit-Taking Institutions Act, 2016, Act 930, and Non-Bank Financial Institutions Act, 2008, Act 774, to carry on banking business. Or B. Before the making of the invitation, the written consent of the Commission has been obtained to the making of the invitation, and the invitation is made in accordance with the conditions and restrictions that the Registrar has imposed. 2. The Commission may grant or withhold the consent, and without limiting the generality of this subsection, may require the Registrar tie-on with an approval by the Registrar of an advertisement or a circular to be used in connection with the invitation. 3. Where an advertisement or a circular used in connection with the invitation contains an untrue statement, then, subject to subsection 4, a person who made the invitation and a person who was a director of a body corporate making the invitation at the time when the advertisement or circular was published, is liable to pay compensation to the persons who deposited money with the public company on the faith of the advertisement or circular for the loss they may have sustained by reason of the untrue statement. 4. A person is not liable under subsection 3 if that person proves a. That that person had reasonable grounds to believe and did believe up to the time of publication of the advertisement or circular that the statement was true. Or b. That the advertisement or circular was published without the knowledge of, and that on becoming aware of its publication, that person forthwith gave reasonable public notice that the advertisement or circular was published without the knowledge of that person. 5. Where a person deposits money with a public company as a result of an untrue statement of a material fact made, whether innocently or fraudulently, in an advertisement or a circular published in connection with an invitation to the public made by or on behalf of that company, that person is entitled to require the company immediately to repay the money with interest at the yearly rate of 5%, or a higher rate as may have been agreed to be paid on the deposit. Skip sections 317 and 318. Done.